A- AB 2498.
Thank you, Madam Chair and colleagues. I'm pleased to present AB 2498 today, which brings justice to human trafficking victims by strengthening survivor protections and by holding exploiters and buyers accountable. It does two things. It allows human trafficking cases to be a priority case at the discretion of the judge in our judicial system, and it also provides additional privacy protections for survivors that are opt-in, as well as their immediate family members. We think these are important protections to provide to human trafficking survivors and to help bring their exploiters to justice. I respectfully ask for your aye vote, and I have with me Neil Layton, Deputy District Attorney in Alameda County.
Thank you, and good morning to the chair and the members. I'm Neil Layton, Deputy District Attorney with the Alameda County District Attorney's Office Human Trafficking Unit on behalf of District Attorney Nancy O'Malley in support of AB 2498. As we've heard testimony today, as well as we've experienced and I've experienced personally, is the serious psychological and emotional effects that human trafficking victims suffer throughout the entire process, including the court process. We're in support of this bill due to a long, drawn-out court process only adds to the emotional effects and psychological effects a victim goes through as it goes through the process of testifying and prosecuting their trafficker. For that reason, we're in support of this bill to give priority to human trafficking cases within the judicial system, to prevent a long, drawn-out process, and to give it priority amongst the many cases that we see every day. Move the bill.
Are there other witnesses in support? Witnesses in opposition? Any members have questions? We have a motion already, but we'll put you down as a second. Would you like to close, Assemblyman?
Thank you for your consideration, colleagues. I respectfully ask for your aye vote.
This bill is due pass to approbes. May we have a roll call vote?
Hancock. Anderson.
Aye.
Anderson, I. Glazer.
Aye.
Glazer, I. Leno.
Aye.
Leno, I. Liu. Liu, I. Monning.
Aye.
Monning, I. Stone. Stone, I.
The bill's on call for other members to add on. Thank you.
Thank you, Mr. Chair and colleagues.
Do you have a second one?
Yeah. Item 36.
Item number 36, AB 2792.
Yes, Mr. Chair, thank you. AB 2792 is the Transparent Review of Unjust Transfers and Holds Act, otherwise known as the Truth Act. We've taken some amendments in this committee, and just to clarify what those are, those amendments clarify that the agreement may be an MOU between local government entities or a policy adopted by a local government. Those amendments also increase the length of the MOU or policy to a period of 3 years. They reduce the number of hearings required for cities that are small, defined as less than 100,000 residents, and they protect immigrants in their interactions with law enforcement on CSU, community college, and K-12 campuses. As we all know, California's immigrants are an incredibly valuable part of our community and our state, but many of them, unfortunately, are living in constant fear of having their families torn apart and too often are unable to turn to the police to keep them safe. Pedro Figueroa was a victim of car theft. When he sought help from the SF Police Department, he ended up in custody. He was only recently reunited with his family after months in custody. Maria Hernandez is a domestic violence survivor and was afraid to go to the police for fear of deportation and leaving her 3 U.S.-born children without their mother. It doesn't have to be this way, and back in 2013, the legislature took a very important step when we passed and the governor signed then Assemblymember Amiano's Trust Act. Prior to the Trust Act, Immigration and Customs Enforcement, or ICE, requested that local jails hold community members until they could be picked up for deportation. The Trust Act stopped this practice except under limited circumstances where the community members had certain more serious prior convictions, but that hasn't stopped ICE, unfortunately. Now ICE and local law enforcement are making agreements, often behind closed doors, to help with deportations, separating families, and making undocumented victims and witnesses afraid to step forward and seek help from those who are responsible for protecting them. Rather than asking local jails to hold immigrants, they are instead asking for advance notice when the community member is to be released so that ICE can be waiting to pick that individual up in an unmarked van. It's an end run around the purpose of the Trust Act, and something that the Truth Act, a loophole the Truth Act seeks to close. With the Truth Act, we can put an end to these secretive and deceptive practices, and the Truth Act establishes a transparent process, including community engagement prior to local law enforcement participating in ICE deportation programs. Local law enforcement must reach an agreement with their city council or county supervisors dictating the terms and conditions of any participation that they will have with ICE. And in short, the Trust Act has been undermined. The Truth Act seeks to strengthen the areas where the Trust Act has been abused. We have a broad coalition of supporters, from the Asian American Advancing Justice to National Day Labor Organizing Network and many others. And we think this will create a better environment for our immigrant communities, as well as provide the needed transparency and openness in government that's necessary before there's participation in some of these deportation proceedings. So I want to thank you for your consideration. Joining me to speak in support of the Truth Act today are Laura Polstein, Immigration Staff Attorney at Centro Legal de la Raza, and I also have with me Victor Alvarez Ortiz, a student at Long Beach City College, whose father, Jose Alvarez, was deported this February when the CSU Long Beach police transferred him to ICE after a traffic stop for a broken headlight.
Witnesses in support?
Yes, thank you. Good morning, Senators. My name is Laura Polstein. I'm an immigration attorney at Centro Legal. We're a nonprofit organization, and we provide deportation defense to individuals throughout California. I'm actually speaking to you today on behalf of my client, Guillermo Hernandez, who was scheduled to attend but unfortunately couldn't be here. Guillermo is an immigrant from Mexico who's been living in the United States since he was 7 years old. He went to elementary, middle, and high school in Southern California. He was in immigration custody from January 25th to April 14th of this year, and he is still actively facing deportation. On January 25th, Guillermo had attended a routine court hearing in Riverside County. At that hearing, both the judge, the district attorney, and the public defender agreed that he could resolve his pending charges by attending a rehab program, which I should add is a great example of our progressive, restorative policies that we have here in California. Unfortunately, in Guillermo's case, justice was thwarted. ICE showed up to that hearing as well. 2 plainclothes officers arrested Guillermo in the hallway, I believe actually the elevator of the courthouse that day, and from there he was taken to a remote detention center in Southern California near the border. He was detained for over 2 months. We strongly suspect that Guillermo's detention was due to some sort of entanglement or collaboration between the local authorities and ICE. We suspect that the local authorities provided some sort of information to these officers that showed up and arrested him, tearing him from his family, including his U.S. citizen fiance. On March 14th, 2016, Guillermo and his husband Tom, who's a U.S. citizen and a Marine Corps veteran and a longtime activist, made history by having the first ever same-sex wedding in immigration custody. Sadly, instead of being able to enjoy his honeymoon, Guillermo was behind bars. Centro Legal was able to secure Guillermo's release on an immigration bond, actually the minimum amount, which reflects that he did not pose neither a danger nor a flight risk. But sadly, the nightmare wasn't over. He was rearrested and redetained by the county because they say that he missed a court date on February 9th while he was actually in immigration custody. So ICE in this case swooped in the middle of the proceedings, took him away. He wasn't able to attend his court date and wound up back in jail. So this is what happened when ICE gets involved. This is what happened when ICE gets involved with our local processes. And we strongly believe that because of Guillermo's cases and many other cases like that, that if a county wants to entangle itself with ICE, that the public should have a chance to have a say in that process. We need to pass the Truth Act to shine a light on what's going on.
Next witness, please.
Good morning. I'm here in support of the Truth Act. My name is Victor Alvarez. I am a student at Long Beach City College. I am one of 6 siblings, all born and raised in the United States. My father, Jose Alvarez, was deported on February 21st after Cal State Long Beach police stopped him for a broken headlight and then turned him over to ICE. That night, my father was on his way to pick me up from work. I saw him outside my drive-thru window as he was pulled over by the Cal State police. So I immediately clocked out and to see if everything was okay. the police officer had told me that he had to ring out my father's name, and that an immigration hold appeared on his name. We were waiting for him to clear, and he gave us the green light that everything was okay and free to go. After a few seconds after that, the car wouldn't start, so the officer had pulled up again and told us to go inside our car again. It turned out that ICE had called him back and asked him to detain my father. At that point, my father knew something bad was going to happen. The officer arrested my father, took him to Cal State Police Station. At 1 a.m., we got a call saying that ICE had picked up my father. 4 hours later, we got a call from my dad saying to pick him up from TJ and to bring him clothes because he had just those clothing that he had that day. The last thing my father told me before the police had taken him was to work hard and to support the family. Right now, my whole family is struggling. The police took him, and I'm currently planning to put school on hold right now. I have to work full time to provide for my family. The problem of police getting involved with deportation enforcement affects a lot of people. I don't want this to happen to anyone else, to drop out of school, to support their families when their parents get deported. Thank you.
I've let the time limit far exceed. So moving forward, if we have other witnesses in support, we need me toos. I'm going to cut you off if you go into great detail. Other witnesses in support?
Good morning. Catherine Brandenburg, representing Alameda County Board of Supervisors in support.
Thank you.
Good morning. Khalif Osagai, California Public Defenders Association in support.
Thank you.
Andrew Medina of Asian Americans Advancing Justice California in strong support.
Thank you.
Rosa Akil with the Alliance for Boys and Men of Color in strong support.
Thank you.
Jeanette Sadefatin on behalf of MALDEF, as a co-sponsor, also in strong support.
Thank you.
Micah Doctoroff on behalf of the ACLU of California in strong support.
Thank you.
Dennis Cuevas Romero on behalf of the California Attorneys for Criminal Justice and the California Latinas for Reproductive Justice in strong support.
Thank you.
Jessica Cabrera Carmona with California Immigrant Youth Justice Alliance with 13 youth organizations throughout the state, ranging all the way from Stockton, San Diego, and Sonoma.
Thank you.
Stacy Saw with California Immigrant Policy Center, co-sponsor and in strong support.
Thank you. Do you have witnesses in opposition? Do you have any questions or a motion? Senator Leno?
Thank you, Senator Anderson. Complex issue. Unfortunately, of course, we're getting nothing out of our U.S. Congress. And I think we're going to see more and more painful and unfortunate, unnecessary situations like we heard from Victor and others until there is some resolution. But I don't think any of us want to hold our breaths. What disturbs me most is, as you had mentioned, Assemblyman, the secret nature of these backroom deals between law enforcement and ICE. Bring it out into the open. You want an MOU? Do it. Let there be public comment, participation. Let the public know what you're doing. But they don't. They do it secretively. And the idea of secret police and secret law enforcement, I think, is antithetical to what our whole culture is about. So I'm very supportive of what you're doing. And if there's the opportunity, I would like to be at it as a co-author.
Thank you, Senator.
Thank you. Principal co-author, if you can do that.
I think we can arrange that.
It's that important.
Thank you.
Senator Stone?
And I make the motion.
Thank you.
Thank you, Mr. Chairman. I certainly understand why sanctuary cities were formed in an effort to allow law-abiding immigrants to work in cities like San Francisco, Los Angeles, Indio. My concern, there's a couple. It takes a MOU between a local governing body and their public safety officer, whether it be a sheriff or a chief of police. My first concern is, are we putting that, in many cases, an independent elected official, such as the sheriff of a county, is he being asked to do something that is contrary to federal law, number one. And number two, if the local governing body says that a sheriff's department cannot have any communications with ICE, how do we deal with very dangerous felons that are immigrants? Obviously, we had a very heinous example of this in San Francisco with Kate Steinle, where we had a man that was deported not 2, not 3, not 4, 5 times, and then killed Kate Steinle in cold blood. Under your bill, would the sheriff of San Francisco County not even have, would he not even have the opportunity to contact ICE pending the release of this dangerous individual? Would your bill stop that communication?
Thank you, Senator. Some important questions, and I'm glad you've raised the issues that you have. First, sheriffs, while independently elected, are different than police chiefs, who are typically employees of the city. So that's why we've made some distinctions in the bill between an MOU and a policy. And certainly at the city level, when the city is responsible, the city council and the mayor is responsible for the policy for the city, and the police department and the police chief are the police chief is an employee of the city, we think this makes sense. I understand your point about an independently elected official in the sheriff. In those cases, that we also have an elected board of supervisors. They're in charge of the budget and how the money is spent. And one of the things I believe they have an important duty to fulfill is determining how that money should be spent, including whether resources and money should be dedicated to working with ICE to deport members of the community. So I think they have a role as well. And they also have a role in terms of sharing with the community what is happening. To Senator Leno's point, I think we all agree in the concepts and principles of open government and sunshine and transparency. So having a community meeting to talk about what the policy should be and should not be, we think is important. So I think there's a role for the Board of Supervisors. I understand your concern. I've given it some thought. I just think that on balance, there is an important role for a Board of Supervisors, even when there's an independently elected sheriff. We're not asking the sheriff to do anything that's contrary to law. We still will observe and recognize the federal law that allows for sharing of information regarding an undocumented Californian. But the Trust Act hasn't raised any red flags about violation of federal law. We haven't gotten any indication that our bill will violate federal law. So we think we can observe federal law and move this bill forward and have it passed at the same time without any tension or violation of federal law. For the Pier 14 incident that you mentioned, first I'll say this, obviously a tragic incident that none of us, all of us would have taken steps to avoid if we could. Also, we shouldn't base policy for tens of thousands of individuals on a single incident. I think our policy needs to be the best policy for the most people. You heard the testimony that I shared and that the witnesses here today have shared about how victims of crime are victimized again and set through deportation proceedings, how fathers visiting sons in college campuses as their children fulfill their dream of an education in California because of a traffic light are being deported. We think this policy makes sense for the most people and expresses our values, especially in the face of the federal government's inability to act with respect to how we embrace and value our immigrant communities.
And if I may add regarding the federal preemption issue, my name is Angela Chan. I'm a senior staff attorney and policy director at the Advancing Justice Asian Law Caucus in San Francisco. And we have looked closely at this issue. There is no federal law that requires the transmission of information about someone's release date and time. There's no requirement that that individual be reported to immigration. So there is no conflict with federal law. Also, I should note that under this bill, it does not prevent the fingerprint sharing that does occur at the point of arrest between local law enforcement and immigration.
Okay, thank you. So just lastly, just to answer my question, if this was the law at the time of Kate Steinle's death and the San Francisco Board of Supervisors were to have had an MOU that said that you would not be communicating with ICE, would this disastrous, horrific event happened as it did, the San Francisco sheriff would not have been able to notify ICE that a dangerous individual was being released?
If I may respond, I'd appreciate it. I'm located in San Francisco and have looked in detail at that case. And I should say that that was a horrible tragedy that occurred, but it was really a tragedy that was exploited by anti-immigrant forces nationally and some of our anti-immigrant politicians at the national level. And really, if one were to look deeper at the facts of the case, they would see that it's the issue of where did the gun come from? It was a stolen gun from a federal law enforcement official. That's a huge problem. And the use of stolen guns from law enforcement is an issue that we need to work on statewide. Another issue that happened is why was this individual even brought back to San Francisco? It was an old warrant that did not even need to be responded to. And so I think we need to look at those causal factors that really preceded anything in terms of the immigration issue, and that really should be our focal point. And I think it's been disappointing to see the national anti-immigrant rhetoric that has circled around this case.
I appreciate your comments, and just one final comment, Mr. Chair, and I'm finished.
You know, moving forward, though, you're not going back and forth. You're going through the chair. So when he asks, it's a one-way deal there. Go ahead.
My only hope would have been that this MOU would have been between an elected body and a public safety officer as far as communicating with ICE for a person that has no felonious background. If they have a felonious background, it would be my opinion through the MOU that there should be some language that would allow the public safety officer to communicate with immigration officials. But thank you.
Thank you, Mr. Senator.
We have a motion from Senator Leno. Would you like to close?
Yes, I think this bill represents the values that we have as a state in California that we've shown so many times, from support for our dreamers to embracing of our immigrant communities in multiple ways. I think it's an important step to build on the Trust Act, which is being undercut right now by practices that are occurring in the field. And with that, I thank you for your consideration, and I respectfully ask for your aye vote.
This bill's due pass to appropriations. May we have a roll call vote?
Hancock. Anderson.
No.
Anderson, no. Glazer. Leno. Aye. Leno, aye. Liu. Aye. Liu, aye. Monning. Aye. Monning, aye. Stone. No. Stone, no.
The bill's going to be on call, so other members may add on. Thank you very much.
Thank you, Mr. Chair, colleagues, and staff.
Assemblyman McCarty's next. I'm not sure if he's going to no, he's going to go ahead and present. Okay, so it's McCarty.
So, Assemblymember McCarty, you're up. And
I think Assemblymember Cooley said Assemblywoman Melendez can go next. And he was going to let her go ahead of him, but apparently McCarty's not.
Okay. So you have item number 1, AB 450.
No, there's no process, but they're going to bring it.
Sit down.
Absolutely.
Thank you, Mr. Vice Chair and members. I'm presenting to you AB 450, which we think is a narrow bill related to a growing issue facing local governments as they administer and deal with the financing of CCW permits. First of all, I'd like to thank that the chair and the staff are working with us on proposed amendments to the bill outlining the analysis. I will be accepting those committee amendments. And before I get going what this bill is, I just thought it'd be maybe helpful for the record to say what this bill doesn't do, that this bill doesn't change who can apply for a concealed weapon permit in California, does not change the requirements to attain one, doesn't change who could issue one, and doesn't make any other substantive changes to the CCW law. Granted, that's a policy and a debate for another day. This simply deals with the issue related to the fees charged by either the sheriffs or the police department to cover the costs of obtaining, enforcing, and administering these policies. right down the street here at our Sacramento County Hall of Administration, the Board of Supervisors recently discussed this issue and found that the current fee structure in place wasn't fully covering the program. And the shortfall had to basically be addressed out of the general fund, not allowing them to fund other vital programs like public safety, parks, and so forth. So we also know that recent examples of bad actors receiving CCWs show that local police and sheriffs don't always have the resources to properly investigate and enforce these permits. There was a really alarming report that came on last few days. A gentleman right across the street here at the Hyatt Hotel, the housekeeping staff found his room full of ammunition, weapons, and all other sorts of things. And after being arrested by the police department, it came to the conclusion that he was a potential mass shooter. And so what we've seen is with the proliferation of these permits, the law enforcement agencies don't always have the tools and the resources to make sure that it's working. And so I think this is a common sense fix, and I respectfully ask for your aye vote, and I have a few witnesses with me today. Thank you.
Okay, witnesses in support. We have 2 witnesses with 2 minutes.
Great. Madam Chair, thank you, and honorable members of the Senate. My name is Susan McKee, and I serve as Chief of Staff to Supervisor Patrick Kennedy of the Sacramento County Board of Supervisors, and I'm also representing Supervisor Phil Cerna with these remarks. The Sacramento County Board of Supervisors recently deliberated and voted on next year's 2016-2017 recommended general fund budget. And during those budget hearings, Supervisor Cerna raised an important matter, whether or not discretionary general fund monies should be used to fund the administration, processing, and issuance of carry and conceal weapons, CCW, permits. It was discovered that in the last few years, since 2010, CCW issuance has significantly increased by thousands each year. In fact, more than 8,000 permits were issued in less than 6 years. The prolific issuance of carry and conceal weapons permits in Sacramento County has had a noticeable budgetary impact. According to the data collected at Supervisor Cerna's request, it is projected that by the end of the current fiscal year, Sacramento County taxpayers will have incurred more than $620,000 in net costs to administer the CCW permits since 2010. These are funds in excess of the various fees collected through the Sheriff's Department for activities such as background checks. In fiscal year 2015-16 alone, it is projected that CCW permits will cost our general fund approximately $250,000. This is a disconcerting number for a number of reasons, not the least of which is that these are scarce discretionary resources that could be used for a great many other worthy purposes. During our budget discussion, for example, Supervisors Kennedy and Cerna explained that these funds could go to augment funding for very successful home visitation programs that had identified operational shortfalls. The point was also made that instead of appropriating from general fund to continue aggressively issuing CCW permits, funds could instead be used to enhance deputy patrols by well-trained law enforcement officers. Given our frustrating and unfortunate experience in Sacramento County, the supervisors respectfully request that the Public Safety Committee please give careful consideration to this legislation, which would require all CCW permit administration, processing, and issuance costs be paid for entirely with fees charged to permit seekers, and that local general funds be insulated from any and all use for the administration, processing, and issuance of CCW permits. Legally carrying and concealing firearms in the state of California is a privilege and should not cost the average taxpayer who is not seeking it, should not cost them. Please support Assemblymember McCarty's proposed legislation that would accomplish this laudable objective. Thank you.
Next witness.
Madam Chair and members, thank you for the opportunity to speak. My name is Consuelo Hernandez. I'm the Chief of Staff for Sacramento City Council member Steve Hansen, who unfortunately had to leave. As Susan mentioned, this is an issue that has really come to the forefront recently in Sacramento County. What is being asked of in AB 450 is a narrow fix. I think it stands to reason that fees should be sufficient, the fees charged should be sufficient to cover not only the processing, but the oversight of concealed carry permits. Oversight especially is a critical function, as the Assembly member mentioned. A report came out recently documenting numerous instances in which the sheriff had to rescind a permit due to some issues with the permit holder. And we need to be sure that appropriate funding is available to cover the costs of this program, and it is not done at the expense of other critical needs. I ask for an aye vote. Thank you.
Are there other speakers in support of the bill? Please just give your name and position.
Amanda Wilcox on behalf of the 27 chapters of the Brady Campaign to Prevent Gun Violence, including the Sacramento Valley chapter, in support.
Thank you.
Rebecca Gonzalez. I'm here as a volunteer with the Brady Campaign to prevent gun violence, and I'm with the Sacramento Valley chapter. Thank you.
Thank you. Are there speakers in opposition to the bill? Okay, we need to make room at the dais for the opposition.
Madam Chairman, members of the committee, Craig DeLuz with the Firearms Policy Coalition and a constituent of Mr. McCarty's. First of all, let me just say that to limit debate and discussion to 2 witnesses for 2 minutes on an item that was a gut and amend that has existed for less than a week, and is quite frankly an issue area that has.
Excuse me. To save time, I made clear in the beginning when you were not here that gut and amends are different, so you can go on. And issues that have basic constitutional issues, which we also have a few of today. So.
Madam Chair, if I may, I didn't realize that was a gut and amend, and I'm the one that reiterated your rule, so I'm at blame. Madam Chair had made that clear in the beginning. I didn't realize this was a gut and amend.
Thank you, Mr. Vice Chairman and Chairman. First of all, I think it's important to note that during the support portion of this particular testimony, notice that law enforcement was not here. Notice that the individuals who are seeking to implement or who are tasked with implementing this as a part of their ministerial duties weren't here, weren't seeking additional funds, seeking additional resources. I think it's also important to note that what we're talking about here is the ability to enact, or the ability to, in order to be able, for one, to be able to exercise their constitutionally protected right, in this case, to bear arms. There's currently a case that is going through the court process, which talks about the fact that the concealed carry permit process is the only legal method that a California citizen has in order to exercise their right to bear arms. So if we're going to start talking about getting full commensuration for all of the exercising of our constitutional rights, then maybe we need to start talking about, well, do we charge enough fees of people in order for them to be able to register to vote or to vote? Maybe we need to start talking about, do we charge the appropriate level and amount of fees for someone to be able to protest? Things involving property time and the use of that property, as well as if law enforcement needs to be there. Once again, this is about the enactment of a constitutional right. Additionally, this bill includes language that includes enforcement. Now, if you look at the 2 codes that are referenced, neither one of them speak to enforcement. Now, I can only surmise that this is either the idea to come up with something in the future that might constitute enforcement, but the reality is it does not exist. Our concern is that as we see this, much as the DROS fund has been raided time and time again for things that have absolutely nothing to do with registering of a firearm, our concern is that these funds are going to be made available for purposes that have nothing to do with the implementation of the concealed carry permit process in California. It is for these as many other reasons that we oppose this measure.
Thank you.
Good afternoon, Madam Chair and members. Corey Salzillo on behalf of the California State Sheriff's Association, respectfully in opposition to the bill. Existing law requires an entity issuing a CCW to charge a fee sufficient to cover the cost of DOJ to process their part of a license application to carry a concealed weapon. Existing law in that same section 26190 of the Penal Code also allows a local government to charge a fee of up to $100 to cover their cost of processing. Existing law also allows for a local government to charge a fee of up to $25 for a renewal and up to $10 for a replacement license. All of those fees are subject, in the case of the DOJ fee, to a COLA that is statutorily approved by the legislature. The local fees are permitted in current statute to be increased based on a rate not to exceed CPI as calculated by the state government of California. So there is provision and wiggle room for the fees to be increased to cover costs. Simply put, the sheriffs think this bill is unnecessary. We think existing law covers the fees that need to be charged and the costs that are in place. We also would point to Penal Code Section 26190 subdivision G, which effectively says that aside from the listed fees that I've just mentioned, that no other fees or conditions are to be placed on the issuance of a CCW. And so obviously the legislature could amend that section, but if the bill is allowed to remain as it sits, that provision and this statute and this bill as it sits would be in conflict with one another. So we just point that out, probably more for logistical purposes. But in the end, sheriffs believe this bill is unnecessary. We think the existing law provides local control, and that's what we support, and so we would oppose the bill.
Thank you. Others in opposition?
Madam Chair, members, Sam Paredes representing Gun Owners of California. A lot of the points important to this bill have already been made by my colleagues. But I had a conversation with the sheriff with regards to this bill, and he was being questioned by a reporter, and his response was this: I ran for office committing to issue concealed weapons permits to law-abiding citizens if they passed all of the provisions of the law, and they did. He charged the total level that the law would allow to cover the expense. He did everything he could to have volunteers and former law enforcement officers, former FBA agents to process the permits and to do everything completely above board. And he had to use some of his discretionary funds. The sheriffs have a discretionary budget where they can allot resources to different things. Bottom line here is that some people don't want the sheriff to support that part of his responsibility. The sheriff pointed out, you know, we fund all of our youth programs through these discretionary funds, and we aren't allowed to raise any money. We can't charge a permit, a license, or anything to raise money to do those things. Does that mean we're going to stop doing those things? No, our commitment to the community is to do all of the things that are vital to the community, and we have the resources and the budget, and that he has the responsibility, and he's answerable to the voters. For these reasons, we are in opposition to this bill. Thank you.
Madam Chair and members of the committee, for the record, Dan Reed with National Rifle Association, also representing California Rifle and Pistol Association today. My colleagues here have really hit all the high points, so I won't reiterate them, but we're in strong opposition to this bill. This just seems like a bias towards permit holders and an effort to price them out of the market. So thank you.
Okay. Are there others in opposition to the bill? Seeing and hearing none. Senator, Assemblymember McCarty, would you like to answer or respond to some of the concerns raised by the opposition?
Sure, and I'm not sure if we have questions or comments from committee members. I think it's fair to say when this process went into place years ago, we put in statute a number in there as far as what the fees would be, and the goal was to have a structure that covered the costs. And as we're seeing here in our local county, and I would imagine in jurisdictions across California, the framework we have in place doesn't currently address that. So we think that this is a simple opportunity to allow sheriffs and jurisdictions to recover the fees that pay for the service like we do for many other services. And so I would ask for your aye vote. Thank you.
Thank you. Are there questions or comments from members of the committee? The bill has been moved by Senator Liu. I think this is adding flexibility and local control for law enforcement, so I will certainly be supporting your bill today. Assemblymember, and would you do the roll?
Hancock.
Aye.
Hancock, aye. Anderson.
No.
Anderson, no. Glazer. Leno. Lou. Lou, aye. Monty. Stone.
No.
Stone, no.
Okay, that's 2-2. We'll hold the roll open for the absent members.
I think it's a